I'm an attorney with the Environmental Integrity Project based in Philadelphia. First, I'd like to thank DEP for reopening the public comment period and holding this hearing for the draft NPDES permit. DEP's stated mission is to protect Pennsylvania's air, land, and water from pollution and to provide for the health and safety of its citizens through a cleaner environment. The Clean Water Act requires DEP to issue NPDES permits that require facilities that plan to pollute to limit how much they will be discharging and to monitor their discharges. New large dischargers in particular must meet the most protective standards. We are here tonight because the draft permit DEP has released for the Shell cracker plant is deficient, and the public has many unanswered questions about the pollution from this facility, which will discharge a variety of toxic pollutants. First, strict compliance with pollution regulations is important because Shell has a history of risky compliance issues at petrochemical plants. For example, Shell was just fined $91,800 in May of 2016 for violations at the Shell Norco chemical plant in Norco, Louisiana, related to risk management plans, which are required under the Clean Air Act for facilities that use extremely hazardous substances. This plant is also, that same plant, is also in significant noncompliance with the Clean Water Act for failing to submit discharge monitoring data for any of 2016, according to EPA's ECHO compliance database. In addition, the draft permit for this site fails to require Shell to comply with all of the limits that are legally required to keep the public safe. DEP requires TDS limits for new dischargers. DEP and Shell both admitted throughout the application and the draft permit that Shell is a new discharger and that this is a new type of industrial facility. But DEP's draft permit would impose no limits at all on TDS, or total dissolved solids. DEP accepted Shell's argument that its new discharges are somehow existing based on an exemption in the regulations for maximum daily discharge loads that were authorized by the department prior to August 21st, 2010. That is false. Shell is not an existing discharger of TDS. This is a brand new facility. The old facility has been demolished. This is an entirely new industrial waste stream, as Shell and DEP have admitted in the materials. And finally, DEP never authorized the TDS load for Horsehead zinc smelters discharges at all prior to 2010. They applied for a permit in 2006 that, according to DEP's website and the materials available, was not approved until 2015, well after the 2010 TDS limit was in place. There was no TDS load that DEP had authorized during that time. DEP must impose TDS limits that were adopted. DEP itself has admitted that the major concerns with high concentrations of TDS in water are adverse effects it may have on aquatic life, human health, and drinking water supplies. I'll wrap up. In order to adhere to its own stated mission, DEP must deny Shell's amendment application and require Shell to submit a new application that is required for all new facilities and must release a new draft permit that holds Shell to all applicable water pollution requirements. Thanks so much.
Thank you.